Hello, and welcome to this fourth episode in our CM Murray podcast series on private equity investment in the legal professional services sector. I'm Zulon Begum. I'm a partner at CM Murray, specialising in partnership law and advising professional services firms matters. In our previous episodes, we explored the strategic, remuneration and governance implications of PE investment in law firms. Today, we're going to turn to the regulatory landscape, an increasingly complex and critical area for both law firms and investors to navigate when thinking about investment in law firms. And I'm joined today by my two brilliant colleagues. Firstly, Corinne Staves, who's a partner at CM Murray and advises on law firm structuring, governance and regulatory compliance. Corinne brings deep insight into how law firms can prepare for and manage regulatory change. And Nick Leale, a partner in our regulatory and professional discipline team, who is a leading expert in advising law firms and individuals on SRA compliance and investigations. And together, we're going to be unpacking the key regulatory issues that arise when law firms take external investment, from the initial structuring and licensing considerations to the responsibilities investors must be aware of, and finally, the ongoing compliance and obligations that come with this new model of ownership. So whether you're a law firm considering PE backing or an investor looking to enter into the legal services sector, this episode will help you understand the regulatory realities and how to prepare for them. So firstly, we're going to kind of focus on what the issues that law firms need to consider at the outset. And obviously structuring and having the right regulatory license is quite critical, isn't it, Corinne? Do you want to talk us through that and the requirements and the process for getting the right license?
So traditionally, law firms were all comprised of law firm owners and managers. So everybody that had either a management influence or an ownership stake in the firm was a lawyer in the sort of layman's terms. Obviously, that's all changed, and you can now have non-lawyer managers and owners. And the most common scenario in which we see this is where you might, for example, bring your FD into the partnership, or your sort of head of IT or your head of HR. So we see lots of firms that have brought in non-lawyer managers and or owners. Often it's both manager and owner. The technical term for that is a licensed body. More often it uses the term ABS, alternative business structure. They're one and the same thing. But what that just really means is that there are people who are non-lawyers who are involved in management or ownership of the business. So clearly, if you're accepting investment from a PE house, for example, whatever structure you choose, the likelihood is that they're going to have some kind of direct ownership stake. And therefore, the firm will need to be regulated as an ABS, as a licensed body. Now, you could say, well, okay, great. In that case, we'll get ready. We'll become an ABS, so we're ready to accept PE investment. It doesn't quite work like that, because the regulator regulates the specific management influence or the specific owner. So you couldn't say, let's be an ABS ready to bring in a non-lawyer. The SRA needs to approve the specific non-lawyer owner. So in this case, it would be the SPV, say, backed by the PE entity, that would be approved prior to that new status being taken on by the firm.
And Nick, so how do you think firms should be weighing the benefits of PE investment against the increased kind of SRA fining powers, which comes with becoming an ABS? Is there a kind of a trade-off there, do you think?
Well, ultimately, there's no choice. If a private equity business wants to purchase a law firm, it will become an ABS. And that increases the fining powers for the SRA from a very small amount of £25,000 to the potential fine of 250 million. Now, that's obviously a huge increase, and that is brought about by the fact that the internal team are likely to use their broader powers when it comes to regulatory enforcement. And it's not just about the figures, really. It's more about the fact that internal team is the lead and the ultimate decision maker in relation to most regulatory interventions. For example, if there is an AML breach, the internal team can form a view and propose that a particular fine is imposed. And that's a very small level if it's not an ABS, but obviously up to those huge numbers if it is an ABS. And there's a sliding scale of where that figure lands depending on the seriousness. So it has to be accepted that that's the implication. And the internal team at the SRA have got those powers and they use them. And they can use them without referral to the Solicitors Disciplinary Tribunal, which is even greater risk because there's obviously the implication of costs if there is a dispute to be had and a fight to be had over that regulatory decision.
And I've never actually got to the bottom, Nick, as to why there are differing treatment between the traditional recognised body that most law firms are versus ABSs. Yeah. Are you able to shed some light on that?
Well, it's disproportionate. There's no doubt about that, and it gives the internal lawyers at the SRA, the internal team at the SRA, a lot of power to impose very large fines. The difficulty is for those who face that situation is there's only one alternative to accepting what is proposed, and that is to oppose it and go to the Solicitors Disciplinary Tribunal and incur what will be significant costs, obviously.
Obviously, it's a factor to think about, but obviously it hasn't stopped firms becoming ABS, whether it's for external investment or other reasons for example, bringing in some of their non-lawyers into their partnership. So it's obviously hasn't stopped firms kind of going down that route. So let's think about the actual transaction itself and how the regulatory implications will affect the transaction process. And what things that firms must think about from a regulatory perspective. So obviously there's been a big fallout from the Axiom affair and a warning notice from the SRA that came out of that, and that has quite wide-reaching implications, doesn't it, in terms of kind of M&A in the sector, including when you're taking external investment. So Nick, what are the regulatory risks when using PE to fund acquisitions in this kind of transaction?
Well, as a result of the warning notice that came out post-Axiom, which probably is just the beginning of all of this, the risk really is of regulatory intervention in relation to the transaction, and there are a number of different potential stumbling blocks, not least the fact that Principle 7 is very clear. It doesn't put it quite like this, but clients can't be treated as commodities. There must be proper informed consent to the transfer of their work to any new entity and sufficient notice given of that so they can properly consider it. It's very important that all client monies are reconciled very carefully, and again, time is allowed for that, and generally proper due diligence is done in relation to the business. And wherever any of that isn't done properly, there is the risk, particularly in the environment post-Axiom, of the SRA becoming involved. It's inevitable that their interest in any kind of acquisition of this kind is going to be substantial, and they will want an early report in relation to it so that they can engage their minds to the client interests that may be affected by the acquisition. So a huge number of potential slipping points from a regulatory perspective as any transaction progresses.
Corinne, from a practical perspective, when you're managing transactions, when you're advising on these things, how do you kind of envisage the firm managing those risks as part of that kind of, say, DD process and finding the right buyer, or even at the outset, actually finding the right buyer? And, you know, ultimately, how will this affect firms' kind of ambitions in terms of growth and external investment, do you think?
It's a tricky one, isn't it? I honestly think that as a profession, we're quite sophisticated, so we sort of got our head around a lot of the issues and the regulatory framework in which we all operate. As Nick quite rightly points out, the warning notice and the regulatory framework generally sort of highlights the key things we need to think about. Clearly, if it's a pure investment issue, then there might not be a transfer, so some of those points might not be engaged. But other things that are raised in the warning notice, like, for example, confidentiality, making sure that you're not sharing, for example, a list of your clients with a potential investor, is because they're going to be a third party. So there's lots of touch points where the SRA would be interested. I think there are ways and means of the profession making sure that it is fully compliant. Clearly, that's a really high priority for law firms. So I don't think this is going to be a barrier, but I do think that firms need to think carefully about those regulatory points like confidential information. It could include, for example, having letters of engagement where consent is given to share information in specific circumstances. Now, clearly, you'd have to reflect on whether that's informed consent at the relevant time, but that could be a good way to manage some of those risks if a growth strategy involves acquisition or merger or sort of transfers of those sorts of things. It will depend whether you are the first firm that accepts PE investment, that you are kind of effectively the platform, because likelihood is that your business will remain intact, or whether you are a business sort of being bolted into an existing PE structure, and what that looks like. If it involves a business transfer, all the things that Nick has talked about become relevant. If you are sort of remaining intact but under a sort of a PE umbrella, that will be different. So it will vary on a case-by-case basis. I do think that the SRA's approach is likely to change. Obviously, we've had reprimands, for want of a better word, from the LSB, and some clear direction of travel that the SRA needs to travel into to make sure it is properly managing these risks. That's resulted in, for example, a consultation on client monies, which we're still waiting to hear about. And I think we will see some focus on acquisitive behaviours in the profession, but I think that's fraught with difficulty. It's not as simple as saying let's introduce a rule, because it is accepted by everyone, including the SRA, I think, that they are under-resourced and add delay to everything they touch, frankly. And I would say that to them openly. They will accept that as something they need to work on. And they probably don't have the sort of sophisticated resource to be able to look at a merger transaction and troubleshoot issues and spot issues in a way that the principals couldn't. So I think there is a real difficulty there that if the principals haven't spotted the issue, it's unlikely that a regulator will do so. I know they will look at it from a different perspective, but it's quite a complex issue to solve. And so that question of how the regulatory framework will evolve, because I think it will, is still an unknown. But I think that where you have a growth strategy and you know what you want to achieve, and firms are used to working within a certain framework, they'll just adapt their strategy, make sure they're fully compliant. So again, I think it will translate into perhaps cost and delay, but there seems no doubt that the legal profession will comply with whatever it's required to comply with in order to deliver that growth strategy.
Thank you, Corinne. So let's kind of focus a little bit on actually culture, because culture is really important in any kind of strategic major change, like taking an external investment or selling your business, and how that kind of impacts your internal workplace culture, and also the ethical risk issues that might arise as a result of quite major strategic change in strategic direction. And obviously we have the workplace culture guidance from the SRA as well to think about. So how do you think, Corinne, that a firm that's taken on external investment, which may have to kind of pull up its bootstraps in terms of delivering financially, and being any investor will be very much focused on delivering kind of financial results and performance, and that will inevitably have some impact on the culture of the firm. So in that kind of financial targets driven culture, how do you think the actual culture of the firm might change as a result of that, and will that have an impact in terms of its ethical considerations and the SRA kind of guidance notice on the workplace culture itself?
I think that a lot of PE houses would say that they're actually in the business of retaining that culture. Part of what they want to sort of buy into is the relationships and the way that the business operates. But I think another reality is that part of what PE is looking for is buy low and in 3 to 5 years sell at a higher price, and therefore you've got to find a way to deliver that enhanced value. Now that could be because people are more productive, and that could be because you invest in technology, for example, but there will be a shift in culture as people adopt to new working practices. I think fundamentally there will be a need to generate more business, to generate more value from either existing clients or win new clients, and that is going to translate into different pressures on people within the business. Hopefully it wouldn't lead to undesirable business practices. For example, partners feeling such pressure to deliver against targets that they make bad client acceptance decisions about business that they wouldn't necessarily have accepted if the environment had been different, if the culture had been different. I think that culture can also be affected, that if there is a clear focus on strategy, maybe some firms might say, well, actually this particular team is not delivering at the sort of the levels of profitability, or it's not part of our core strategy. So now we've got to say goodbye to this team or this partner or whatever it is. Now, I'm not saying that that shouldn't have happened in a non-PE backed firm. It probably should have done in order to be a very effective, very productive firm. But if you are owners and managers of the own business, you can make bad business decisions if those people are your friends. Maybe that's part of the culture. Again, I'm not saying one is right or one is wrong, but if you see the shape of the partnership change, if you see the shape of the practice and the strategy change, then that can lead to different pressure points, which could result in difficult behaviours. I think the other thing is that if people are extremely stressed, and again, I'm sure that PE houses would be at pains to say that they are not in the business of making people extremely stressed, but I think that's a risk in an environment which is trained to sort of to drive growth and drive year-on-year growth in order to result in a sale. Then you might see some really extreme behaviours, like some of the things that the workplace culture notes particularly focuses, like maybe bullying behaviours if people are so stressed that they are taking it out on the team. Maybe, I'm sorry to say it, but the getting drunk at a Christmas party and doing something extremely out of character. Again, hopefully not. You might see serious illness, for example, people suffering from stress and burnout and having absences due to mental health illness, and that can in itself lead to risk management fails because you've got different people looking after workloads, deadlines gets missed. That there are lots of different things that feed into that, and I wouldn't say they're exclusive to PE-backed businesses, but I think that the risk profile certainly changes, and the leadership team has got a really key role in making sure that culture, those strong positive parts of the business, ironically the reason why PE wanted to invest in the first place, are retained and actually enhanced by the changes that are brought with that external investment rather than undermined.
That's the key point ultimately, because paragraph 1.5 has been added to the code of conduct that obviously mandates individuals to treat colleagues fairly and with respect and refrain from bullying and harassment. It does additionally say that managers within the firm have a responsibility to ensure that there is such a culture and to challenge any behaviour that falls short of those standards. So the risk is that the nature of the new business brings real challenges in relation to the new-ish paragraph 1.5 of the code of conduct. And it will be vital that everybody understands exactly how far that goes, both in relation to every individual within the business and particularly the managers, so that those good cultures are maintained.
Is there anything that firms should be doing to, ensure that they're mitigating some of those heightened ethical risks? Nick, as at the outset, is there anything that you would suggest?
The important thing is to remind everybody of the obligations upon them and ensure that they have regular training in relation to it, because the way the SRA polices that aspect of law firms and ABSs does move forward, and you can learn exactly how they intend to enforce it by looking at the sort of cases that come before the SDT or are agreed by way of regulatory settlement agreements by the SRA. And it's important to make everybody aware of that so that they know exactly where the lines are.
Okay, so let's kind of switch it around a little bit and think about it from the PE investors' perspective and what they should be thinking about in terms of regulatory issues. And a lot of PE investors have some experience of already investing in law firms already, but there are some who are coming new to this sector, and I think may not be aware of the quite stringent regulatory burden that the SRA places on law firms and lawyers generally. So they may be educating themselves on some of these kind of the environment itself. So from a PE investor's perspective, what are the kind of responsibilities they will be taking on when kind of, any PE investor will be looking to appoint their own people to the board, for example? So what are the things they should be thinking about when they're kind of appointing people to the board and the responsibilities that those people will have on an ongoing basis?
I think it'll be useful for the individuals who are selected for those roles to be really trained well and have a deep understanding of the legal services sector. We've all seen examples of law firms where non-lawyers come into the business, and there can be some resistance to that sort of external influence. I'm not saying that should have happened, but you do see that. So a group of people who truly understand how law firms work and how to get the best out of the people within the business, I think is on a very pragmatic level. I think that there'll be questions, and we covered these in the last discussion, so I don't want to reiterate those points about sort of understanding the reporting lines, understanding who can decide what, understanding where one set of responsibilities lie and another starts, those kind of really effective lines of responsibility. I think that honestly, again, the PE firm will be quite keen to stand back and let the existing management, so far as is possible on a day-to-day level, continue to run the firm, because the reason they invested is because they saw the potential in that firm and the opportunity in that firm. And again, they won't want to upset that balance too much, I wouldn't have thought. I think that the dynamic might be slightly different if the firm isn't delivering against the business plans, against the strategies that the firm said that they would deliver again. I think then you'll get slightly more scrutiny and involvement from the investment side. And so I think there's a big sort of melting pot there. I think that on a regulatory, so bringing it back to the regulatory perspective, these people will just have to understand the sector, the regulatory burden, the obligations, but that is no different from other owners and managers of firms. So lawyers who operate have grown up with the SRA, but this is something you can learn. This is something you can be trained in, and I'm confident that those investors will want to understand the environment in which they operate. Most of them are financial services regulated anyway, so they're sort of understanding of being in a regulated environment, and it's just a question of understanding where the touch points are and how that business needs to operate in order to be effective and compliant.
The regulatory pitfalls in a law firm are substantial. The new owners are going to have to bear that in mind and put regulation and regulatory compliance right at the heart of the management of the firm. The CULP, or HULP as it's known, is in an ABS, does need to be at the heart of management, so that the sort of issues that we've talked about are considered at a senior management level on a regular basis. The same goes for the COFA, particularly at a time of acquisition where there may be complex client money issues or just general financial stability issues to consider. And also, the business has to consider very carefully the issue of BOOMs, beneficial owners, officers, managers. Officers being directors of the firm, managers being those who are at the heart of operational management. First of all, they have to be registered as BOOMs, and also consideration has to be given to them about how they sit within the management structure as well, so that they've got proper influence over regulatory behaviours.
Actually, external investment, this could be one area where that external investment really helps deliver for firms, because often you hear firms talking about the increased regulatory burden, the cost of operating the business and those sort of overheads, and often firms are looking to consolidate, whether that's through merger or whether it's through sort of combining onto sort of joining an existing platform, for example. Actually, the platforms being set up with a PE backing can provide that centralized risk management and regulatory compliance function centrally, so that you're not finding lots of smaller businesses each having to have their own operation with the sort of budget constraints they're operating within. By centralizing that, by developing effective systems and processes, actually this is one area where I think that external investment will say actually it's delivering both more effective, sort of cheaper offering, but at a greater level. And I think that that actually regulatory compliance is an area where I think external backing should be delivering more efficiencies at a greater level of skill and competence, done well, of course.
So let's think a little bit about kind of conflicts and confidentiality and how that can affect the PE investor itself, and obviously whether it affects what the law firm itself can do going forward in terms of acting for certain types of clients or being prevented from acting from certain types of clients.
Well, it's interesting, isn't it? There are some regulatory complexities there. I don't think that any of them are barriers necessarily, but there are a number of regulatory matters to take into consideration. Think about conflicts, first of all. You couldn't, for example, as a law firm, be litigating against a certain PE firm if that PE firm was one of your investors, for example. I think that the own interest conflicts issues there would be too complicated to resolve, and I'm not sure that you'd be doing a great job for your client if you were hoping that they didn't win, for example. So I think you've got to think about the own interest conflict issues there. But I think those should be fairly manageable, because that's going to come up in very few circumstances. I suppose firms might say, well, can we operate in the PE world if we are PE backed? And I think the answer to that question is going to be yes, really, isn't it? It's such a big industry. But within that, there are going to be complexities. To what extent is confidential information gained during client matters accessible to, say, an external owner? Because let's think of a PE house that has a number of portfolio companies. There could be information held on the law firm's systems that is relevant either to an acquisition or to something like that. So there will need to be systems and processes that make sure that confidential information is only accessed in appropriate ways. Again, I'm not suggesting for a minute anybody would misuse that information, but you need the systems to be supportive of the correct ethical behaviours. I also think that there could be some challenges if you have a PE house that backs a couple of law firms. For example, could you have PE house here that has a stake in both law firm A and law firm B? Can those two firms have a dispute and litigate against one another? Can you have those as two law firms on opposite sides of the same transaction? Again, I think the rules are sophisticated enough to be able to work through the different complexities, but they are all things that need to be taken into account to try and work out how that works. And on a pure practical level, the law firm's systems and processes, for example, for conflict checking purposes, need to be sophisticated enough to take into account external interests that, say, the external owners have in making sure that you're not accepting instructions from clients where you might have an own interest conflict that might either, well, an own interest conflict obviously couldn't be resolved, but either a relationship conflict or a pure conflict. You need to pick those up, and therefore the systems would need to evolve as a result of that external ownership.
Which does mean that both the law firm and the PE investor have to be really proactive in ensuring that the information is up to date. PE firms are constantly buying and selling businesses, so making sure that the law firms are aware of what their portfolio looks like, for example, regularly is going to be important.
We're sort of envisaging here the kind of the initial transaction with a PE house, sort of that first one you talked about, sort of dealing with it from the outset. But let's not forget that in 3 to 5 years, the original PE investor is going to want to sort of to sell out and to come out of the business. And the likelihood is that a secondary investor is going to come in, or there might be a listing or something, but it seems most likely that another PE investor will come into the business. And again, I think that there might be scope for issues there, because you've become used to working, you've kind of grown up with the original investor, but when you suddenly have a second investor, to be blunt, imposed upon you as a law firm, then you must make sure that those systems and processes are effective enough, first of all, to have checked whether you can do it in the first place, but second, that you can operate effectively from day one. And I wonder whether the likelihood is that we'll see more issues kind of in that secondary transaction rather than the initial one, where those issues will have been given a vast amount of thought.
Yeah, that's an interesting point. We will wait to see when some of these investments kind of eventually go into the second round. Just to finish off on the issues that PE investors should be thinking about, and it's linked to the culture issue that we talked about earlier, and how kind of law firms, as they evolve with a different model with the external investors, how that kind of impacts their kind of workplace makeup in terms of equality, diversity, and inclusion. What are the kind of regulatory and reputational expectations around EDI, Nick? And what should the PE investor be thinking about when around that specific issue, and how the impact of their investment will have on the EDI requirements and expectations within the firm?
Well, you might not be surprised to hear that on this area of EDI, the SRA are heavily involved and quite interventionist, and have significant expectations that probably exceed other professions, in fact. And in fact, some professions have got close to imposing actual requirements for active promotion of issues relating to EDI, and step back from that. But the SRA are absolutely clear that any organisation that they regulate must create a workspace and environment that is free from discrimination and actively promotes fairness, inclusion and respect for all. And that extends in all sorts of different directions: equality of opportunity and diversity in operations, having an inclusive approach to just about everything that goes on in the business, encouraging diversity at all levels of the workforce. There's an expectation that every 2 years the firm collects, reports and publishes diversity data. Ultimately, Principle 6 says that everybody and the firm must act in a way that encourages equality, diversity and inclusion. The business has to have set up very clear systems for the investigation of and addressing of any allegations of harassment or discrimination. Those sort of issues have to, in most circumstances, be reported to the SRA. We'll talk about that in a moment. They need to monitor and review diversity, have a policy statement. And again, it comes down to senior leaders having to take, and the SRA are very clear about this, having to take responsibility for EDI, making sure that ultimately that builds trust, engagement and loyalty within the business, and that they as a team help remove barriers in relation to proper inclusive recruitment, promotion and progression within the business.
Some PE houses will have their own kind of ESG criteria, for example, when investing in businesses. So that it might be very high up on their agenda already, notwithstanding the regulatory implications of investing in a law firm. But Corinne, in the general sense, how can a PE investor itself kind of help support a law firm in kind of meeting its EDI objectives and requirements under the SRA requirements?
It probably goes back to the points we touched on earlier on culture, in the sense that it all should be tied up in the way that the firm operates, the decisions it makes, the way it operates, the way that the leaders lead, those sorts of questions. EDI should be sort of infused into every decision they make and every action that they take. The good news is that there's lots of data that proves that diverse businesses are successful businesses because clients are a diverse bunch. And if it's one thing that PE understands, it's money and success. So hopefully that sort of alignment will be apparent, and therefore that will also help drive that alignment around EDI within businesses. I guess one observation I would make, though, which is slightly at odds with the theory that we've been discussing, which is that, anecdotally at least, there doesn't seem to be great diversity in the senior levels within PE businesses, and therefore one worries that some of that lack of diversity would start to trickle down into the businesses that are owned by or backed by those PE houses. Now, perhaps I've overgeneralized there, but I think that is a pretty well recognized problem, and people talk about the PE blokes, and I think that's probably fair. I heard that comment used just the other day, and therefore I think that it's just something that legal services firms will be very mindful of in terms of upholding those regulatory obligations around diversity, and that slight mismatch with diverse representation at senior levels within financial services.
And obviously that's going to have a direct impact on who's appointed to the board often. If it's being drawn by the existing management of the PE and they're mostly male, then that's going to filter down into the law firm as well. So yeah, there's interesting aspects to think about, I think, often overlooked. So just to wrap up our discussion, I wanted to kind of touch on the kind of ongoing regulatory compliance for the law firm once it has taken on that external investor. What are the kind of ongoing obligations for reporting and oversight, Nick, that might change slightly because they have a external investor versus being a traditional recognised body law firm that law firms need to be prepared for?
From a reporting point of view, it just needs to be understood that the business does have to report to the SRA anything that may amount to serious breaches of the regulatory obligations that come from the Code of Conduct, both for individuals and for firms. Obviously, it remains vital that proper assessment is done in relation to those sort of issues when they arise. There's far greater risk to the business in not reporting something than reporting it when perhaps it was borderline and arguably didn't have to be reported. And when things aren't reported, it's absolutely vital that a proper record is kept as to why that decision was reached. and it can't be underestimated the risk in failing to draw attention to something which the SRA then become aware of and make inquiries in relation to.
Those are great points, Nick. So how do you think the firm can maintain a really strong compliance culture under its new model and ownership in these circumstances?
Well, I think firstly, by putting regulatory compliance at the heart of what the business does. It comes down to senior leaders ensuring that they take responsibility for these issues and address issues when they arise and don't sweep them under the carpet. It also is dependent upon good systems being in place for noting regulatory risks as they arise and noting incidents when they occur, so that the firm can continue to adapt its regulatory risk profile, its regulatory risk planning, and ensure that things adapt and people are trained on the issues on a regular basis in relation to the issues that genuinely are a regulatory risk to the business, the sort of issues that actually come up.
And let's do a little bit of crystal ball gazing to kind of finish off, Corinne. So what's coming down the pipeline in terms of SRA regulation that the firm and the investor would need to have their eye on and be prepared for, do you think? I think we mentioned a couple of things earlier.
Well, I think that's it, Zulon. I think those are the two key areas that particularly external investors into law firm will be quite focused on. This big question around client monies and what the future is. Obviously, that was triggered by the Axiom Inc. affair. We will just wait and see. I don't think necessarily there's an obvious alternative to law firms holding client money, and that's been brought to the SRA's attention. But it will be interesting to see what the feedback is from that consultation and the representations made to the SRA. The other thing is obviously around transactions and the acquisitive behaviour within the profession. As I say, that's going to be quite difficult. I think we can expect to see more. The warning notice felt a little bit preemptive, and therefore we'll see what happens on how the SRA plans to regulate that sort of acquisitive behaviour and how that's going to work in practice in terms of thinking about timing and thinking about cost, in terms of thinking about capability and sophistication. All those issues are going to have to go into quite a big melting pot to try and work out how that could be managed proportionately.
And just to kind of finish off, what's the kind of key takeaway that you would offer to law firms and investors when it comes to regulatory readiness for external investment?
Money talks, Zulon. Actually, this is an asset in the eyes of an external owner, in the eyes of a PE owner. They want their asset to be worth more when they sell it than when they bought it. And reputation profile is a huge part of that. And reputational damage is done hugely by regulation mishap, by getting things wrong. So I think that actually the law firm, the lawyers and the external owners are all aligned here. A well-run firm, a well-managed, a compliant firm is a much better asset to own. So I think that everybody's interests are aligned. There's going to be strong compliance, and I think that external investment is an area where money can be put into the business to improve compliance, to improve systems and processes, to streamline things, to make things more productive. Very straightforwardly, there'll be a computer system that has a box to tick, and if you say you haven't got an engagement letter or you haven't got a passport or whatever it is that your workflow requires, the computer will say no. And I think processes like that are supported by technology can really improve and make more efficient the law firm business. So I think the future in terms of regulatory clients is bright with PE backing.
For me, the key ultimately is going to be being absolutely clear well in advance of the transaction being finalised what the implication is for clients and how that will be managed, and the ability to demonstrate to the SRA that all regulatory issues have been considered and what the real aim of the acquisition is, so that the SRA can be clear that all those issues have been thought about and are at the heart of the business's thinking before it actually completes the transaction.
So that brings us to the end of today's episode on regulatory considerations for law firms taking on PE investment. A huge thank you to both Corinne and Nick for your brilliant insights. Thank you for sharing those. If you found this discussion helpful, don't forget to check out our earlier episodes in the series where we explored strategy, remuneration and governance in the context of PE investments. You can find them all on our website. And of course, if you have any questions at all or would like to discuss any of the issues that we've mentioned today, please don't hesitate to contact either myself, Nick, or Corinne. Thank you for listening, and we hope to see you in our next episode.